Contracts, Part 4. Essential Requisites 2. We'll talk about consent. We're talking about consent, and now the different vices of consent. First, we have to establish ano-ano ba yung mga tinatawag natin aside from incapacity and simulation of contract. Ano pa ba yung mga factors that will cause to vitiate consent or render it defective to make the contract voidable. Ito yung mga tinatawag natin na mga instances wherein it will cause yung consent na masira or hindi siya nagbibigay ng 100% consent. Because when we talk of consent, dapat dito yung sinasabi nating it should be intelligent, it should be free and voluntary, and conscious and spontaneous. Ngayon, meron ba mga factors that will make the consent hindi intelligent, hindi free and voluntary, or hindi conscious or spontaneous? Okay, may 5. Ito yung error or mistake, violence or force, intimidation or threat or duress, 4, undue influence, 5, fraud or deceit. Itong 5 to. So we will discuss it one by one. What are the causes that vitiate consent and cause the difference between causes vitiating consent and causes of incapacity? Ano ba ang kaibahan ng incapacity at mga causes vitiating consent? Ang causes vitiating consent, the former are temporary while the latter are more or less permanent. Yung incapacity, syempre, more or less permanent. Pero yung vitiating consent, temporary lang yun in nature. Ano pa? Yung causes vitiating consent refers to the contract itself. While on the other hand, yung incapacity to the person entering into the contract. Okay? So, by that, dapat malaman natin, ano ba ang dahilan para umagri siya sa isang kontrata? Okay? And that is vitiating consent. Ano ang ginamit na means? Hindi ba intelligent? Hindi ba free? Hindi ba voluntary, conscious, and spontaneous ang pagkaka-enter into a contract ng isang tao? Unlike on the aspect of incapacitated person, it is the person, regardless whether he is entering into a contract or not. Yun ang ibig sabihin pag sinabi nating difference ng causes that vitiate consent. Okay? We will discuss first error or mistake. Ano ba talaga ang meaning ng mistake or error? Mistake or error is the false notion of a thing or a fact material to the contract. Okay? Ulitin ko ha. It is the false notion of a thing or fact material to the contract. Okay? That is the very meaning of our mistake or error. The nature of which is it may be a fact or a law in general. The mistake to which it refers is a mistake of fact. It may arise from ignorance or lack of knowledge. Okay? The nature of it. Pwedeng fact or law. It may refer to the fact, pero ang importante rito, it will also arise from ignorance or lack of knowledge. The mistake contemplated by law is substantial mistake of fact. Dapat yung substantial, mabigat na mistake of fact. That is, the party would not have given his consent had he known of the mistake. So, ganun kabigat. Kung hindi niya alam at siya ay nagdesisyon in favor, then it is substantial. Pero kung ay maliit na bagay, go na yon. Okay? Ibig sabihin, the reason for a person agreeing to enter into a contract, malaking bagay ang kanilang pinag-uusapan. Hindi lang ordinaryong maliit na bagay. Okay? Hence, not every mistake will vitiate contact. Not every mistake will vitiate consent and make a contract voidable. Kasi kung maliit na bagay, gaya nga nasabi ko, hindi naman kailangan. Okay? Ano ba yung mga mistake of fact to which law refers? First, the substance of the thing, which is the object of the contract. Number 1, those conditions which have principally moved one or both parties to enter into the contract. And number 3, the identity or qualifications of one of the parties provided the same was the principal cause of the contract. Nag-usapan natin sa una, yung substance of the thing. Number 2, the condition. And number 3, the identity of the parties. Okay? Here, dun sa number 1 na sinabi ko, it includes mistake regarding the nature of the contract as when the contracting parties believe that the other is selling when in truth, in fact, both are buying. Okay? Kasama dun yun. Meron ba tayong tinatawag na mistake of fact which does not vitiate consent? Bibigyan ko kayo ng mga instances. Error as regards the incidence of a thing or accidental qualities. Okay? Accessibility of a residential house to means of transportation, maximum speed of a car, not taken as the principal consideration of a contract, it does not vitiate consent unless the error is caused by fraud of the party. Okay? Hindi naman sinasabi basta-basta. Halimbawa, yun nga, yung accessibility ng isang bahay. In fact, kung akong tatanungin nyo, class, with regard to accessibility ng bahay, the buyer should exercise due diligence pag bibili ka ng bahay. Di ba? Bumili ka ng bahay, wow, nasa loob ng village. Yun pala, only to find out na hindi pala maganda yung daan. Di ba? Bumili ka na, mahal-mahal ng bahay. Okay? You should practice due diligence. There may be a mistake or error, but it cannot vitiate consent. Kasi there is a responsibility on the buyer that kailangan niyang tignan. Okay? Next. Ano pa? Mistake as to quantity or amount does not also vitiate consent but only gives rise to its correction. Okay? Mga simpleng bagay, mga amount, and alam mo nang bibilin mo pero may konting mali lang, may konting bawas, and then acceptable yon, babaguhin lang yon, hindi siya para inalify ang isang contract. Okay? As long as yung minimal pwedeng baguhin. But okay, may exception. Pag yung essence of the contract lumabas dun sa essence of the contract, halimbawa, syempre naman, bibili ako ng kotse. Sinabi ko 100,000, yung pala mali lang, sabi ko yung pala 1 million. Kulang ang 0. Ang laking diferensya, no? Okay, pero kung pabarya-barya lang, ayun yung sinasabi nating mistake of law which does not vitiate consent. What else? Error as regards the motives of the contract does not also vitiate consent unless the motives constitute a condition or cause of the contract. Ito yung mga motibo. Okay? Kung bakit mo ginagawa. Pag ito ay based sa condition, based on condition or cause of the contract, then it vitiate the consent. However, kung ang motibo naman ay hindi naman naging cause or condition para maging applicable sa isang kontrata, then it does not vitiate consent. Ito yung mga mistake of fact that will not vitiate consent. Okay? Mistake as regards the identity or qualification of a party does not vitiate consent for the reason that contracts are entered into more in consideration of the things or services which form their subject matter rather than the person. Okay? So, identity or qualification of a party. May exception ba yun? Meron. The exception is when such identity or qualifications have been the principal cause of the contract. Okay? Simple eh. Yung kaya example. Though it is illegal, yung mga mail-to-order bride. Illegal yun, class up. So, hindi siya, pero example lang yun. Pero murder ka, itong mga Tinder, ito yung nakalagay na picture, hindi naman pala yun. Diba? Hindi naman pala yung picture. So, technically speaking, it is a mistake as regards the identity or qualification. So, it invalidates. Example lang yun, class, ha? But, technically speaking, it is illegal. Okay? Ano pa? Error which would have been avoided by the party alleging it, or which refers to the fact known to him, which he should have known by the exercise of ordinary diligence, or which is so patent and obvious that nobody could have made it, will not invalidate consent. Okay? Simple lang yun. Sobrang yung fact is already known doon sa party na nag-a-allege na kahit na ordinary yung diligence ang ginamit, alam mo na. Hindi mo naman kailangang laliman pa ang pag-unawa at pag-iintindi. So, hindi basta-basta may invalidate kasi sobrang obvious. Sobrang obvious nung error na yun. Okay? What else? Ano pa bang natin? Pwede nating i-discuss. Bigyan ko ng example na nga lang, sige, nung which could have been avoided. Kunyari, S was willing to sell his share of 2 parcels of land. Okay? Provided that his co-owners would also sell their respective shares of the said land. May partnership dito sa pag-aari ng lupa. So, S engaged the services of a lawyer without knowing that L, the lawyer, is also representing B, the prospective buyer. Okay? Pareho. So, yung lawyer, tuso, seller and buyer, ang kanyang nire-represent. The lawyer confirmed that the seller, that all his co-owners are amenable to sell the shares. After seller signed the deed of sale drafted by the lawyer, he learned that the other co-owners did not agree to sell their shares over the subject property. So S cannot invoke mistake in order to annul the sale because he could have avoided the alleged mistake. Had she exerted efforts to verify from his co-owners if they really consented to sell their properties. Okay? Ito, may chance ka diba? May chance ka. It is an ordinary diligence lang. Hindi kailangan ng extraordinary diligence. Ang sinasabi kasi ng batas class, kung kailangan effort ka pa para ma-discover, yun ang factor that will vitiate the consent. However, in this ordinary diligence lang, obvious naman na pwede ka naman magtanong sa mga co-owners mo, naniwala ka dun sa lawyer. Kalokohan naman yun. Okay? Effect of simple mistake of account. A simple mistake of account or calculation does not avoid a contract because it does not affect its essential requisites. The defect is merely in the computation of the account or amount which can be corrected. Okay? Simple mistake of account or calculation. Yun yung sinasabi natin, kung konti lang naman ang diferensya, pwede na. Okay? Burden of proof. Effect of knowledge of risk. If a party knew beforehand the doubt, contingency, or risk affecting the object of the contract, it is to be assumed that he was willing to take chances and cannot therefore claim mistake. Okay? Yung knowledge of risk. Alam mo na diba, na merong knowledge of risk and you already assumed to take chances. So, hindi mo pwedeng i-claim na merong mistake. This is especially true where the contract is aleatory in nature. Ibig sabihin, hindi siya principal in nature. Okay? So, that is our understanding about the matter. O meron tayong tinatawag na mistake of law naman. Ano yung mga effect nun? At saka kailan ba siya nag-vitiate ng consent? Mistake of law is that which arises from an ignorance of some provision of law or from an erroneous interpretation of its meaning. Ignorance of the law at saka mali ang pag-i-interpret. From an erroneous conclusion as to the legal effect of an agreement on the part of one of the parties. Ano magiging effect nito? As a rule, mistake of law does not invalidate consent because ignorance of the law excuses no one from compliance therewith. Sabi nga ng batas. That is Article 3 of the New Civil Code. This doctrine is based on public policy dictated by necessity and expediency. Ay, hindi pa pwedeng basta, nagkamali ako, hindi ko alam ang batas. Because ignorance of the law excuses no one. So, ang tanong, when is mistake of law vitiates consent? Kailan ba? Mistake of law does not generally vitiate consent. But when there is a mistake on a doubtful question of law or on the construction or application of law, this is analogous to mistake of fact. The maxim of ignorantia legis neminem excusat. Again, anong ibig sabihin nun? Ignorance of the law excuses no one. Galing, no? Para kayo nagla-Latin class. Ignorantia legis neminem excusat. Ignorance of the law excuses no one. Should have no proper application. When even the highest court are sometimes divided upon difficult legal questions, and when one half of the lawyers in all the controversies on a legal question are wrong, why should the layman be held accountable for his honest mistake on a doubtful legal issue? Okay. Very clear. Napakaganda. Okay? Kahit na sabihin pa nating ignorance of the law excuses no one. Okay? The fact na mahirap ang isang batas, minsan mahirap ang isang batas, hindi rin naman natin pwede kang ma-excuse pa rin. Pero, kung mga madadali na batas, kung yung mga lawyers ka nagkakamali, kung yung mga mahistrado nga nagkakamali, yun pa kayang ordinaryong tao. Yung layman na tinatawag nila. Okay? What are the requisites for the application of mistake of law? The requisites must be present. The error must be mutual. It must be as to the legal effect of an agreement. It must frustrate the real purpose of the parties. The error must be mutual. It must be as to the legal effect of an agreement. It must frustrate the real purpose of the parties. Example. Si D, debtor, borrows 10,000 from creditor. As a security for the debt, it was agreed that the debtor should mortgage his parcel of land in favor of Z. However, the document as written is one of the anti-crisis. Pag sinabi mong anti-crisis, the creditor acquires the right to receive the fruits of the immovable of his debtor. Yung fruits lang. The parties erroneously believing that it has the same effect of mortgage. Okay? So, akala, mortgage, yung pala anti-crisis na nakalagay. So, hindi sila nagkakaintindihan. Gumamit sila ng mga terms na hindi sila naintindihan. So, gamitin nyo yung mortgage instead of anti-crisis. Kasi anti-crisis, yung fruits lang ng mga puno doon sa lupa. So, in this case, the contract is voidable because there is no meeting of the minds. Okay? Okay, very good. So, what else? Give me another vice of consent. Violence or force. Of course, when you speak of violence, it requires the employment of physical force, either be serious or irresistible. Okay? Dapat merong physical force, either be serious or irresistible. When we speak of example, if si X signs a document because every time he refuses, is hit by the butt of a gun which causes blood to flow from his head. There is violence because serious or irresistible force is employed to wrest consent. Okay? Gaya niyan. Pagluto mo ko. Yan. Sabi nung lalaki. Sabi niya, ayoko. Pagluto mo ko. So, nagluto si babae. Kahit na ayaw niya. Kasi sasaktan siya. Okay? Now, Madali lang yung violence or force. Kasi ang tatandaan nyo lang dyan, employment of physical force. And it should be serious or irresistible. Next, intimidation or threat. What is the very nature of intimidation or threat? Dapat, ito yung mga requisites natin ha, importante ito. It must produce a reasonable and well-grounded fear of an evil. Ulitin ko ha, it must produce a reasonable and well-grounded fear of an evil. The evil must be imminent and grave. The evil must be upon his person or property or that of his spouse, descendants or ascendants, and it is the reason why he enters into a contract. Dito, class, uulitin ko, importante ito. Importante itong mga requisites ito. Dapat naiisip ng tao kaya siya pumapasok sa contract ay merong reasonable at well-grounded fear na merong evil na mangyayari sa kanya. Okay? Evil dito dapat ayan na, imminent and grave, grabe. Okay? At kung hindi man sa kanya, ito ay pwedeng mangyari sa kanya, sa kanyang property, sa kanyang asawa, sa kanyang nanay, or sa kanyang anak. At kaya siya papasok sa isang kontrata dahil dito sa evil na posibleng mangyari. Posible na mangyari. So, kailangan ba may physical force? Hindi. Because intimidation is internal while violence is external. Okay, yan tatandaan nyo sa intimidation. Okay? Oh, example. Tuloy natin yung dun sa mananakit para magluto. Kunyari. Okay? Kung sinabi na, hindi na lang yung ganong acting. Sinabi na, sige, papatayin ko ang nanay mo pag hindi mo ako pinagluto. So, the fact alone na nakakatakot yung tao, mukhang nakakatakot, hindi niya kailangang manakit, hindi niya kailangang gumamit ng puwersa, intimidation or threat lang. E nadala ka na, kaya ka pumasok sa isang kontrata, kaya ka nagluto. Kasi yung fear mo, nasasaktan ng iyong magulang, kaya ka napapasok sa isang kontrata. Yun ang tatandaan nyo yung apat na yun, class. And, yung grabe and imminent, parang, ayan na sure na mangyayari. Okay? Factors to determine the degree of intimidation, whether or not the fear is reasonable and well-grounded, or the evil is imminent or grave, depends upon the circumstances. Kasama niya na rin kung consider dyan ay ang age, sex, and condition of a person. Kung malaki naman yung tinatakot, ang lit-lit naman nung nananakot, kailangan din consider yun. Ha? It is important. Kailangan, ito yung totality ng isang senaryo, kailangan malaman. Okay? Threat to enforce just or legal claim. Di ba yung sinasabi natin madalas? The threat of a court action as means to enforce is just or legal is justified. It does not be shaken. Kasi hindi ka naman pupunta sa korte, hindi ka naman mag-file ng legal claim kung wala namang basis. So hindi siya threat as a vice of consent. Diba? Unless demanda kita pero wala namang basis. That is already considered a threat. Pero kung may basis naman yung tao para demanda ka, naman. Okay? Violence or intimidation by a third person. Violence may be employed by a third person who did not take part in the contract. However, to make the contract voidable or annullable, it is necessary that the violence or intimidation must be of the character required in the said law. Okay? Pag yung third person ang nag-intimidate or may violence, papasok pa rin naman yan, provided it is related based on the requisites provided. Okay? So that is intimidation compared to violence. And ano yung kapareho nila? Okay? This time, ano naman yung susunod? Undue influence. Okay? Pag sinabi mong undue influence, it is the influence of a kind that so overpowers the mind of a party as to destroy his free will. Okay? Merong appeal yung isang tao over your mind. para ma-destroy ang iyong sariling pag-iisip, ang iyong free will, para mabago ang iyong free will, and make him express the will of another rather his own. Maraming ganyan, class. Okay? Maraming yung mga tao na nabubuyo. Diba? Nabubuyo to do things. Oh, be careful with that. It is important that you have to establish na yung mga decision nyo, kayo ang nagdi-decide. Of course, the influence must be undue or improper to avoid contract. Dapat undue and improper. Mere general or reasonable influence, hindi sufficient yon. Kaya kailangan dapat dito undue and improper. Pero if gained by kindness and affection or argument and persuasion, hindi rin to kasama. Okay? Kasi gumamit naman ng kindness and affection. Okay? So dapat ito yung mga kino-consider. Anong mga circumstances that will be considered to determine whether undue influence has been exercised. Ito madalas. Confidential, family, spiritual, or other relations between the parties. Kaya di ba usually, sad to say, class, the spiritual leaders should focus on your spirituality. Hindi sila dapat doon sa part. Ano ba, mayroong mga spiritual leaders na, benta mo na yung lupa mo. Benta mo sa ganitong, yung pala, yung pinagbilhan is kikita siya, or kamag-anak niya, or siya mismo. At ginagamit niya yung kanyang influence over that person na kanyang under. Ika nga. Kasama rito actually yung mga teacher class. Because we have a certain degree of ascendancy over you. So, mag-ingat kayo sa mga teacher nyo na gagamit ng kanilang power. Hindi nyo na-realize, ginagamit na nila yung power nila. Mental weaknesses. So, titingnan naman natin doon sa part ng inuudyokan. Mahina ba yung kanyang pag-iisip? Kung mahina, plus, it can be considered undue influence. Kasi mahina na nga utak, ginanyan mo pa. Diba? In-influence mo pa. Ignorance. Kasi may ganun din. Bawa yung mga lawyers. Plus, kadalasan naloloko yung mga tao kasi hindi naman nila naiintindihan. And there are lawyers who actually influences their client to their favor. Okay? Next, financial distress of the person alleged to have been unduly influenced. O, di ba kadalasan, plus yung mga naghihirap at naghihikaw sa buhay, mas madaling mabola. Kaya nga yung mga boto, class, ba? Mas madali silang bulahin. Abutan mo ng pera, ibebenta na yung boto. Pag ako, tatanggapin ko yung pera, pero hindi ko pagpapalit ang future. You vote whoever you think is your choice. Pag-aralan nyo yung mga kandidato, class. Pag-aralan nyo maigi. Okay? Next, the last vice of consent, causal fraud. Ano bang ibig sabihin ng causal fraud? Is the fraud committed by one party before or at the same time of the celebration of the contract to secure the consent of the other. Okay? Committed ito ng isang party before or at the time of the contract. Tandaan niyo yung word na before, ha? Before and at the time of the celebration of the contract, because it is the fraud used by a party to induce to other to enter into a contract without which the latter would not have agreed to. Okay? Ito yung ginagamit na panloloko para pumasok ka sa isang kontrata. Kung hindi ginamit ng panloloko to, hindi ka papasok sa kontrata. That's simple. Yun yung causal fraud. Because yung sinasabi na fraud dito, class, is different dun sa 1170. So ito kasi yung dahilan kaya ka pumasok sa contract. Yung panlolokong ito. Paano ba nangyayari yung causal fraud na yan? It may be committed through machination and insidious words or by concealment. Pwede rin. Pag sinabi mong insidious words or machination, include any misrepresentation in words or actions done with fraudulent purpose. Okay? Pag nagsalita ka, pag may ginamit ka mga Mga bagay to show na ikaw ay nanloloko or panloloko using words, malalambing na mga salita. Okay? For fraudulent purpose. Then, it is a causal fraud, kaya ka pumasok sa isang kontrata. If the fraud did not have the effect of causal fraud that it did not itself alone cause the other contracting party to give its consent, it gives rise only to an action for damages. Kung hindi siya ang dahilan para ikaw ay pumasok sa isang kontrata, then, hindi siya yung fraud na kino-contemplate ng causal fraud. Okay? Pag ganyan, damages lang. The contract is valid, damages lang babayaran. Unlike pag causal fraud, voidable. Okay? Or sometimes void. Okay? Pag hindi na ratified, then voidable. Pag yung fraud ay causal fraud, nasa tao naman yan. Nasa taong tumatanggap. Okay? Requisites of causal fraud. Tandaan nyo itong mga requisites na to. There are 6. First, there must be misrepresentation or concealment. Tinago at misrepresentation. It must be serious, class. Number 2, it must have been employed by only one of the contracting parties. Okay? It must be made in bad faith. It must have induced the consent of the other contracting parties. It must be alleged and proved by clear and convincing evidence. Ulitin ko ha, 6 requisites of a causal fraud. Tandaan nyo, class. There must be misrepresentation or concealment. Number 2, it must be serious. Number 3, it must have been employed by only one of the contracting parties. Hindi ba pwedeng dalawa, class? Pag dalawa, pareho na yung mutual, valid na yung kontrata nun. Okay? Number 4, it must be made in bad faith and with the intent to deceive the other contracting parties who had no knowledge of the fraud. Number 5, it must have been induced the consent of the other contracting parties. Ibig sabihin nun, ito yung bagay na nag-move dun sa contracting party to enter into a contract. And number 6, it must be alleged and proved by the clear and convincing evidence. Dapat clear na clear to. Na ito ang dahilan kung bakit ikaw ay pumasok sa isang kontrata. Simple example. Si seller offered to sell the buyer a ring, isang singsing. Ang claim nila that the stone of the ring is diamond. Seller knows that it is not a diamond but an ordinary glass. Alam naman ni seller, no, puwet ng baso. Kung buyer buys the ring, relying on the truth of the representation of the seller, the sale may be annulled on the ground of fraud. Okay? Simple example. Fraud by concealment. Ano yun? The neglect or failure to communicate that which a party to a contract knows or ought to communicate constitute concealment. Concealment is equivalent to misrepresentation. Okay, an example natin sa taas. Misrepresent niya, sabi niya, diamond. Yun naman pala, puwet ng baso. Okay? Ano ba mga usual exaggerations in trade? It is the natural tendency for merchants and traders to resort to exaggeration in their attempt to make a sale in the highest price possible. When the person dealing with them had an opportunity to know the facts, the usual exaggeration in trade are not themselves fraudulent. Okay? The law allows considerable latitude to seller statements or dealer stock. Yung mga sales stock na yan. Okay? Pwede yan, pinapayagan yan. Customers are expected to know how to take care of their concerns and to rely on their own independent judgment. So, iba yon, ha? Sa sales stock na yan. Huwag kayong papadali basta-basta. Okay? Ano pa? Of course, to constitute fraud, the misrepresentation must refer to facts, not opinion. Dapat facts ang mini-misrepresent. Okay? Ordinarily, a mere expression of an opinion does not signify fraud. In order that it may amount to fraud, the following requisites must be present. Class, yung ibang ordinary opinion ng mga tao, hindi naman yun. Nabawa, nagbigay na maganda, uy, ang ganda. Ang ganda ng painting, pa, totoo. Hindi naman expert yun. So, kailangan kayo mag-rely dun sa expert na alam niya kung ano ang totoong paintings ni Da Vinci, ni Michelangelo. Okay? The other contracting party has relied on the expert opinion. Dapat, kaya ako bibili niyan dahil doon sa expert opinion. And the opinion turned out to be false or erroneous. Okay? Kaya yung expression ng opinion, kailangan expert, at kaya ako binili yan dahil doon sa opinion ng expert na yun, tapos yung pala false and erroneous. Okay? Kailangan sama-sama yung tatlong yun para bago natin masabi na ito ay fraudulent. Okay? Fraud by a third party, a third person has no connection with the contract. Ibig sabihin nun, wala siyang connection sa kontrata. Consequently, a misrepresentation by him does not vitiate consent. A party should not be made to suffer for the imprudence of another in believing the fraud of a third party. Diba? OA naman yun. Parang naniwala kayo sa isang third party na hindi naman part ng kontrata, then hindi siya basta-basta nag-vitiate ng consent. Unless yung sinasabi nating expert opinion. Continue. Effect of misrepresentation made in good faith. If the misrepresentation is not intentional but made in good faith, it is considered a mere mistake or error. Fraud is definitely more serious than mistake. Hence, the guilty party of fraud is subject to greater liability. Okay? Pag good faith, mistake o ano lang yun, ordinary lang, mistake or error lang. Okay? Kasi iba yung pag-fraud eh. Pwede kang kasuhan doon. Gaya na halimbawa, again, halimbawa, yung kay seller natin, nung nagbenta ng singsing, si S, na-realize niya na S realized that alam niya diamond ang kanyang diamond ang kanyang binibenta. Yun pala, not knowing that it's not a diamond but puwet ng baso, then it is just a mere mistake but not fraudulent in nature. Okay? So, all these things should be considered because technically, ito yung sinasabi natin para ma-distinguish nyo. There are two kinds of causal fraud in making the contract. First, it is causal fraud and incidental fraud. When we speak of causal fraud, it is which the ground for the annulment of a contract, although it may give rise to an action for damages. Unlike incidental fraud, which only renders the party who employs it liable for damages because the fraud was not the principal inducement that led the other to give his consent. So, ang laki ng diferensya nun. Okay? Yung isa kasi yun yung cause. Kaya ka pumasok sa isang kontrata. And it may be a ground for annulment as one of the vices of consent. Okay? The other one, hindi naman ito yung dahilan. Pero dahil may nangyaring fraud, the party is only liable for damages. Okay? Requisites for causal fraud. In order that causal fraud may vitiate consent under the rules or the law, dapat it should be serious. It should not have been employed by both contracting parties. Otherwise, ang tawag dito in pari delicto, pareho kayo mali. Okay? In pari delicto, parehong may mali. Pag parehong mali, walang mali. Diba? So, dapat hindi silang dalawa. And number 3, it should not have been known by the other contracting party. Dapat unknown dun sa isa. The seriousness of the fraud is a question of fact depending on the circumstances. It does not mean its influence on the other contracting party, but its importance. Hindi yung influence, pero importante. Okay? The requirement that fraud should be serious excludes slight and usual deviation from truth. Such deviations are frequently present, unfortunately, in transactions, especially those taking place in fairs and market. Okay? O, ano pa? O, ito yung mga simulation contract. Meaning of simulation contract. This is important, class. I want you to understand this ng maayos. Simulation of contract is the act of deliberately deceiving others by feigning or pretending, by agreement, the appearance of a contract which is either non-existent or concealed. Bigyan ko kayo ng example nito, ha. Ulitin ko lang muna ulit. Simulation of a contract is the act of deliberately deceiving others by feigning or pretending by agreement the appearance of a contract which is either non-existent or concealed. Bibigyan ko muna yung mga kinds, class. Kinds muna tayo. Absolute simulation, when the contract does not really exist and the parties do not intend to be bound at all. Absolutely simulated or fictitious contract are inexistent or void. Simple. Void yon. Okay? Kahit anong gawin, void ang isang kontratang ganyan. Ano yung isa? Relative simulation, when the contract entered into by the parties is different from their true agreement. The parties are bound by the real agreement provided it does not prejudice a third person and is not intended for a purpose contrary to law, morals, good customs, public order, or public policy. Example, muna tayo ng absolute simulation. Si debtor may utang kay creditor. Upon learning na si creditor is going to enforce his credit, sabi ni debtor, pretended to sell his land to B. Kunyari, yung father-in-law niya. So, si debtor did not receive a single centavo for the transaction and he continued in possession of the land as a contract was merely simulated. Okay? Yung utang si D, yung utang si debtor kay creditor, sabi niya nakasanla yung lupa. Yung pala binenta na, wala naman natanggap na bayad. Para lang makaiwas na mapunta kay creditor yung property at hindi pa rin naman niya binayaran, na kunyari, naibenta, that is considered simulated or fictitious in nature. Okay? Because no contract of sale in this scenario as the parties do not intend to be bound at all. Okay? Gawa-gawa lang yung papel na yun. Plus, marami kasing nangyayari nito. Birth certificate. Okay? Yung mga birth certificate na simulated na ginawa. Diba? Para may iwasan ng adoption, ang ginagawa paglabas ng ospital, pag pinarehistro sa civil registry, sinasabi na sila yung magulang, pero hindi naman. So that is a simulated void ang ganong klase ng dokumento. Okay? Example ng relative simulation, si debtor and creditor entered into a contract of mortgage, pagsanla, but wanting to hide the mortgage, it was made to appear in the form of a deed of sale. Gusto nila, kunyari sale, pero mortgage pala. Kasi pinalalabas ito sa class, pag hindi nakapagbayad, edi benta na. Dire-diretso na. Pero, ang intention naman nila is, meron sila naman totoong meeting of minds, agreement. Okay? Kaya lang, the effect is, sa kanilang dalawa lang naman. So, pwedeng correct lang yung kontrata. Pero pag may affected na third party, then, yun ang mahirap, class. Because the parties now, what they did is now contrary to law, morals, good customs, and public order. So, it becomes fraud, causal fraud in nature. Okay? So, that's it for our vices of consent. And that is consent. So, the next requisite na ating i-discuss is yung object of contract.